Here's the 30-second lesson on what legends know. Never practice nunchucks in a crowded room. Never eat chole before a road trip. Always take your shirt off before you iron it. Don't take a call near a swimming pool. And don't forget, saving is not investing. Legends don't just save, they invest in mutual funds. Mutual fund investments are subject to market risks. Read all scheme-related documents carefully.
A most important order by a large 9-member constitutional bench of the Supreme Court somehow went in the shade a little bit because of the developments elsewhere in Canada and also in the US. All of North America, we know what happened in Canada and we know that US election results came out. So this 9-judge constitution bench order somehow did not get the attention it should have. Now, I should have talked more about it, but I also got caught up with Canada and US elections. And I'll tell you what, honestly, I also became a little bit hesitant because this is so cluttered and this is so complicated. It goes right back to 1951 from the time our constitution was adopted and put into effect. That I thought that if I get into it, it might take too long. There was too much to read, but I did read. At the same time, I figured that to not talk about this would be a cop-out. And in any case, making sense of really difficult, complex stories like these is the basic proposition of cut the clutter. So why the hell should I not do it? I should not have any excuses. So I'm trying to do this because this is not just the story of a judgment. This judgment came out, you know the basics of the judgment. I will come to that in the course of time. But what got the headlines was the dissent of one judge, Justice Dhulia, and also a part dissent on one observation by another eminent judge of the Supreme Court. But that was about an observation pertaining to yet another most eminent judge of the past, Justice V.R. Krishna Iyer. Now, Justice V.R. Krishna Iyer, he in fact in many ways is central to this, not central just to the judicial evolution that led to this nine-judge constitution bench's order, but also to the evolution of India's political economy. So where do we begin? We begin in 1950. 26th of January, our first Republic Day, our constitution was put into effect. Thank you very much. Wonderful. But what happened with the founders at that point was that they had adopted this constitution, but almost immediately they began to get buyer's remorse. It's a bit like, it's an example I use often. It's a bit like you go to a tourist trap and you want to buy a t-shirt. Somebody says $20. You say, I'll pay $2. The guy says, take it. And then you say, Arey Baba, maybe it wasn't worth $2. That's called buyer's remorse. So this great liberal constitution was signed, put into effect, and immediately people who now had to govern, it was very easy to be liberal when they were framing the constitution, but when it came to the challenge of governance, they began to get regrets that they had given Indians, their fellow citizens, too much power or too much freedom. And that's when our First Amendment came in. It's very ironical because in the US, the First Amendment guarantees total freedom of speech. In India, so the First Amendment to our Constitution enacted on 26th of January 1950, our Constitution was put into effect. And as the rulers of that period got down to the job of governance, they began realizing that they had given away too much to their citizens, or maybe thought that Indian citizens were not yet mature enough to handle so much freedom. At the same time, they thought that they had ideological views. And this constitution was much too liberal to fit in with those ideological views. And essentially that ideology was socialist. So that's how within a year and a half of the adoption of our constitution in 1951 came our First Amendment. In India, the First Amendment actually qualified our freedom of speech and put reasonable restrictions on it. So Article 19 was amended, Article 15 was amended. Article 15 was also a fundamental right, that is to protect citizens against discrimination. And then many other articles, 85, 87, 174, 176. 34, 342, etc., etc., etc. were amended. So Article 31A and B were added to the Constitution. After Article 31, what these two did, I'm trying to keep it as brief as possible. You can read more if you are interested. I will also share some articles with you. What these did was, these gave the government the power over property. So basically, the government was after your property. And that approach came from the government's ideology being rooted in socialism, because this was the time when zamindari had to be abolished, land reforms had to be implemented. And that's where, if property was your fundamental right, how could you implement land reforms? And many of these issues were then landing up in courts. So what did the government do on property? On property, they put these laws, property, they created this special dispensation under Article 31A and B, and then placed these in Schedule 9 of the Constitution, which also came in with the First Amendment. Schedule 9 said that the laws placed under Schedule 9 could not be challenged on the basis of violation of fundamental rights. See the kind of stuff that happened with the First Amendment. If you see the number of articles amended, a schedule added, it's a very long list. But some of the ideas were also very important. For example, reservation for scheduled castes and tribes. Now, if you were to give reservation, then somebody could have gone to court saying my fundamental right of protection from discrimination has been violated. That's why Article 15 was amended as well. So this dispensation was created within a constitution with these massive changes. One, to bring in reservations for scheduled castes and tribes and to protect these reservations from constitutional challenges. And second, to give the government the powers over property. Now, the idea was to abolish zamindari, to carry out land reforms. But you know what? The government always comes at everything with a sledgehammer. In the process, they gave themselves overwhelming power over all citizens' property. So what happened as a result? How do I explain it? It's a bit like, remember that Airtel ad? It's my favorite example. Jo tera hai, wo tera hai, jo mera hai, wo mera. In this case, the Indian state was telling the citizen, jo mera hai, wo mera hai. That means what the state owns, the state owns. Jo tera hai, wo bhi mera hai at my discretion. If I want to take it, I can take it. Now, as you go ahead in the Constitution and you go towards directive principles, there is also 39B. Now, 39B says that government generally, that the state shall endeavor to distribute available resources, I'm simplifying it, maybe oversimplifying it, in such a way that this works towards a larger common good or towards the betterment of the community. So, Article 39B, it's a directive principle, not binding, but that, because it's a directive principle, it gave moral authority to the government to say, I will take anything that a private citizen has or that a private company has in the larger interest of the community. And that's how a lot of the nationalizations were carried out in the future. Now, we talked about the First Amendment. This founded the socialist state of India. The word socialist might have been put by Mrs. Gandhi in the preamble of the Constitution during her emergency rule in an illegitimate parliament in its 6th year. But India started out being a socialist country with these amendments, because these powers were taken by the government, but they were not done yet. By 1955, and this is the time when the Congress party is coming up with the industrial policy resolution, etc., that's being prepared to take over, basically to take over all of India's business and industry, give the government monopoly in most sectors. While that is happening, in that socialist wave, the Fourth Amendment also comes. Fourth Amendment comes on 27th April 1955. This once again amended Article 31A to put more restrictions on property rights and also place many other laws under Schedule 9. These laws had to do with zamindari, with feudal rights, etc., because land reform was going on. So this was the second round of a socialist set of amendments to our constitution pertaining to property. Then we wait for almost 15, 17 years. Nobody is quite questioning the socialist state, but Mrs. Gandhi comes to power. She splits the Congress party in 1969 and she has to take a more pronounced left turn. Also because her government is surviving with the support of the CPI, Communist Party of India, and also she's come very close to the Soviet Union, whose support she needs for many things, including ultimately in the war against Pakistan for creation of Bangladesh. That's when the Indo-Soviet Treaty of Peace, Friendship and Cooperation was signed. It was in that leftward move that she nationalized the banks. When she nationalized the banks, that was challenged in Supreme Court, and Supreme Court 11-judge bench struck it down, right? Struck it down as unconstitutional because they said that even under Article 31A, 31B, it was necessary that the government pay a fair compensation to those whose property it was taking, and whether the compensation was fair or not was subject to judicial scrutiny. She didn't like it also, so she came up with another set of amendments, and this came in through the 25th Amendment. 25th Amendment passed on 8th of December 1971, right in the middle of the Bangladesh War. Bangladesh War began on 3rd of December, ended on the 16th with the liberation of Bangladesh on 8th of December 1971. The 25th Amendment was passed, which inserted Article 31C as well. But now that she had brought in Article 31C through the 25th Amendment, this came under a cloud yet again with the Keshwanand Bharati judgment, where a 13-judge bench, a 7-6 order said that there was a basic structure to the Constitution. And these 31C, etc., were then located in the basic structure of the Constitution. That's when Mrs. Gandhi started saying that the thinking of the higher judiciary in India was not progressive enough. They were not socially relevant in their thinking right now, and that's when she wanted radical changes. That had to wait for the emergency, and it is during the emergency that she brought in the 42nd Amendment. If you see the number of sections, articles amended under 42nd, you can see that 42nd actually had the effect of rewriting our entire constitution. 42nd was passed over 3 days, over 3rd January, 1st February and 1st April of 1977. Just mark the dates, because this is when she's ending towards the end of the emergency. So all these damage is being done to the constitution in the run-up to the end of the emergency, because she was also creating a scorched earth, and she was also creating a big socialist politicized agenda, and she thought that might work with the people of India. It didn't ultimately, because people of India are smart. Later, it took yet another set of amendments by the Janata government, the 44th, which undid a lot of this damage, but not all of this damage. So what happened in the process was that some of the laws, some of the articles on property, they stayed in the books. In 1978, the Janata Party government repealed Article 31 of the Constitution and replaced it with Article 300A. What 300A said was, it said that a citizen has the right to their property, but it's a constitutional right and a legal right. It is not a fundamental right, which means that if the government still wants to take your property, government can take it, provided the government gives you a justification under the law and also pays you an adequate and fair compensation. But government had total power, and that power was again drawn from Article 39B of the Directive Principles of State Policy. Now, while this is going on, the emergency is over, 1977, but our most preeminent socialist judge or leftist judge, in fact, I will happily say a communist judge, because he had contested with the support of the Communist Party in Kerala in the 50s. He had also served as a minister in the left-front government there, Justice V.R. Krishna Iyer. Later, by the way, 1987, he also contested for president against R. Venkatraman of the Congress Party, that is after retirement. In 1977, another case came up in the Supreme Court in front of a 7-judge bench. This was a case of Karnataka government versus the transport operators, because what the Karnataka government did was 1976 every Congress government started passing these ordinances and laws basically to grab everybody's properties and assets. I told you the principle was जो मेरा है वो मेरा है, जो तेरा है वो भी मेरा है. So in Karnataka, they passed an ordinance saying that all these guys have trucks and buses and all that, contract carriages, right? All of this is distorting our economy. It's not serving the cause of the poor and community by and large. So we will grab all of this. So they nationalized all of that. This 7-judge bench actually upheld that law in Karnataka. They upheld that law, but there was a difference. The majority judgment, so Justice Untwalia wrote the judgment for the majority. It was a 4:3 order. In fact, interestingly, some of the eminent members in that 7-judge bench rose to be CJIs. For example, Justice Y.V. Chandrachud was on the side of the majority. Justice M.H. Beg was then also in majority. Then the serving CJI and P.N. Bhagwati, who was on the other side, on the side of the dissenters, he also rose to become CJI in the course of time. So this was a very eminent judge. 4:3, they upheld the order, but within this, while upholding the order, Justice Krishna Iyer wrote a separate order. The majority order said that Article 31 itself gave the state enough power to carry out this nationalization. There was no need to go into Article 39B. Justice Krishna Iyer was not to stop at that, because he believed in Article 39B because he was a socialist. And he gave a dissenting judgment. While agreeing with the order, he gave a dissenting judgment saying no. And I quote the line that Justice Krishna Iyer used in his orders. He used to write long orders, and long before Shashi Tharoor, before the arrival of Shashi Tharoor maybe wasn't even in college yet, Justice Krishna Iyer had made his fame for writing judgments for which people had to buy thesauruses. I will only read a short sentence for you from Krishna Iyer's order. He said, to exclude ownership of private resources from the coils of Article 39B. From the coils of Article 39B is to cipherize. Once again, have you heard that word before? I hadn't. Is to cipherize, usko zero kar diya, is to cipherize its very purpose of redistribution the socialist way. So this was a judge of the Supreme Court enshrining the socialist system in India and insisting on it. Now what happened was, the majority judgment was forgotten. Majority logic in the judgment was forgotten because it did not have the oomph for sex appeal, right? Because they had just upheld an ordinance of Karnataka government. This dissenting judgment from Krishna Iyer, it had ideological juice. And that is what several benches in future subsequently, particularly in a case called Sanjeev Coke versus Bharat Coking Coal Limited. That was also a case about nationalization of coking coal mills in India, again carried out by Mrs. Gandhi in a flurry of nationalizations. They relied on this logic, and this became the guiding principle for many orders subsequently until economic reform began, particularly in early 1990s, and judges now began to raise questions about it. In each case, they kept on pushing it to a larger bench or asking for a larger bench. So this case, this MHADA versus Property Owners Association, this has also been kicked down the decades from 1991. It's taken more than 30 years. I don't know how many of the petitioners are around and how old they are. So what has happened now? What's happened now is that this 9-judge bench, the constitutional bench, they have not set aside Article 39B, they have not struck it down. They've also not said that all owners of property will have total rights over their property. So it's not as if the right to property given to us citizens as a fundamental right has been restored. All they've said is that the government, the state still has the power to take it from you, but everything that you have does not belong to the state. They can't take everything. They have to give a reason for what they want to take, and a lot of what is private, what is owned privately, cannot be taken by the government. Now, exactly what that is something that will be probably specified in future orders. I will read a line from Justice Chandrachud's order for the majority in this case. It says, and I quote, interpretation of Article 39B adopted in these judgments, that is judgments going back to V.R. Krishna Iyer, interpretation of Article 39B adopted in these judgments is rooted in a particular economic ideology, socialism/communism, I'm adding that, in a particular economic ideology and the belief that an economic structure which prioritizes the acquisition of private property to the state is beneficial for the nation. Thus, there was a need to settle the debate with respect to whether private resources fell under the purview of the material resources of a community under Article 39B. Then, apparently, looks like in some draft, he had added a line which was a criticism of Justice Krishna Iyer, and that is something that Justice Nagaratna objected to. Interestingly, we know that in the final order that was written, this line was not there, so probably a draft was circulated among the judges, to which Justice Nagaratna responded and wrote her criticism of this particular point. She is not dissented from the judgment, from the order, but only on this argument, which is fascinating because it's wonderful to see top judges, eminent judges arguing on point of principle. So Justice Chandrachud's order supposedly said it had a line which is not available in the final order as it's published. And I quote from what Justice Nagaratna has referred to. The Krishna Iyer doctrine does a disservice to the broad and flexible spirit of the Constitution. Now, to reach this argument, Justice Chandrachud says, and I quote from him again, the role of this court is not to lay down economic policy, but to facilitate this intent of the framers to lay down the foundations for an economic democracy. And then he goes on, or supposedly goes on, with this criticism of Justice Krishna Iyer, to which Justice Nagaratna has taken umbrage. And she says, I say that the institution of the Supreme Court of India is greater than individual judges who are only a part of it at different stages of history of this great country. Therefore, I do not concur with the observation of the learned Chief Justice in the proposed judgment. Now, the interesting thing is that if you read Justice Nagaratna's order in detail, she also gives you how India has changed. That before, she doesn't use the word before and after the Cold War, but that is what she's referring to. She's saying that there was a time when everybody thought socialism was the way, and then came perestroika. And India also saw with the 1991 reforms the equivalent of perestroika playing out in India. And that's how the logic that the judges took ideologically before that period, it's not fair to criticize them now. However, the fact is that that logic has not only been challenged, but in a way it's been set aside or modernized, which is why this is such an important order. And once again, the irony of ironies, Jawaharlal Nehru is the one who took away a right to property, also curtailed a right to free speech. And then Mrs. Gandhi made it even more sweeping, the state control or state power to possess our property and our earnings and our assets. Now, as this constitution bench debated these very issues, even the BJP was in court fighting to preserve the same powers on behalf of the state. So once again, I will tell you, this is how the Indian state thinks. This is how the Indian state thinks, and this is not even so ideological. This is a bit of opinion. This is not even fully ideological. This also comes from the state always wanting total power over the citizens. To that extent, this order has not resolved everything. Definitely, this has not restored right to property as a fundamental right, but this has really moved the needle forward.